communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21st and July 25th, 2019 telephone calls, as well as the President's September 25th, 2019 meeting with the President of Ukraine in New York. B, all investigations, inquiries, or other probes relating to Ukraine, including any that relate in any way to 1, former Vice President Joseph Biden, 2, Hunter Biden and any of his associates, 3, Burisma Holdings Limited, also known as Burisma, 4, interference or involvement by Ukraine in the 2016 United States election, 5, the Democratic National Committee, or 6, CrowdStrike, C, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF. D, all documents, communications, notes, and other records created or received by Acting Chief of Staff Mick Mulvaney, then National Security Advisor John R. Bolton, Senior Advisor to the Chief of Staff Robert B. Blair, and other White House officials relating to efforts to 1, solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations, 2, offer, schedule, cancel, or withhold a White House meeting for Ukraine's president, or 3, hold and then release military and other security assistance to Ukraine. E, meetings at or involving the White House that related to Ukraine, including but not limited to 1, President Zelensky's inauguration on May 20th, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and subsequent decision about the composition of the delegation of the United States. 2, a meeting at the White House on or around May 23rd, 2019, involving, among others, President Trump, then Special Representative for Ukraine negotiations, Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union, Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3, meetings at the White House on or about July 10th, 2019, involving Ukrainian officials Andrei Yermak and Oleksandr Danieluk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and subsequent meeting in the wardroom. 4, a meeting at the White House on or around August 30th, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5, a planned meeting later canceled in Warsaw, Poland, on or around September 1st, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence. And 6, a meeting at the White House on or around September 11, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney concerning the lifting of the hold on security assistance for Ukraine. F, meetings, telephone calls, or conversations related to any occasions in which the National Security Council officials reported concerns to National Security Council lawyers, including but not limited to National Security Council legal advisor John Eisenberg regarding matters related to Ukraine, including but not limited to 1, the decision to delay military assistance to Ukraine, 2, the July 10, 2019 meetings at the White House with Ukrainian officials, 3, the President's July 25, 2019 call with the President of Ukraine, 4, a September 1st, 2019 meeting between Ambassador Sondland and a Ukrainian official, and 5, the President's September 7, 2019 call with Ambassador Sondland. G, any internal review or assessment within the White House regarding Ukraine matters following the September 9th, 2019 request for documents from the House Permanent Select Committee on Intelligence, the House Committee on Oversight and Reform, and the House Committee on Foreign Affairs, including but not limited to documents collected that pertain to the hold on military and other security assistance to Ukraine, the scheduling of a White House meeting for the President of Ukraine, and any requests for investigations by Ukraine. H, the complaint submitted by a whistleblower within the intelligence community on or around August 12, 2019, to the Inspector General of the intelligence community. I, all meetings or calls, including requests for or recordings of meetings or telephone calls, scheduling items, calendar entries, White House visitor records, and email or text messages using personal or work-related devices between or among 1, current or former White House officials or employees, including but not limited to President Trump, and 2, Rudolph W. Giuliani, Ambassador Sondland, Victoria Tunstang, or Joseph DeGenova, and J, former United States Ambassador to Ukraine, Marie Masha Yovanovitch, including but not limited to the decision to end her tour or recall her from the United States Embassy in Kiev, and 2, the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the United States Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The Majority Leader is recognized.
I now ask for a brief 15-minute recess before the parties are recognized to debate the Schumer amendment. Therefore, I ask consent the Senate stand in recess subject to the call of the chair.
Without objection, so ordered.
1999.
That was Majority Leader Mitch McConnell earlier on the Senate floor talking about
The Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
I'd like to state that for the information of all senators, the trial briefs filed yesterday by the parties have been printed and are now at each senator's desk.
The following documents will be submitted to the Senate for printing in the Senate Journal. The precept issued January 16, 2020, the writ of summons issued on January 16, 2020, and the receipt of summons dated January 16, 2020. The following documents, which were received by the Secretary of the Senate, will be submitted to the Senate for printing in the Senate Journal pursuant to the order of January 16, 2020. The answer of Donald John Trump, President of the United States, to the articles of impeachment exhibited by the House of Representatives against him on January 16, 2020, received by the Secretary of the Senate on January 18, 2020. The trial brief filed by the House of Representatives received by the Secretary of the Senate on January 18, 2020. The trial brief filed by the President received by the Secretary of the Senate on January 20, 2020. The replication of the House of Representatives received by the Secretary of the Senate on January 20, 2020. And the rebuttal brief filed by the House of Representatives received by the Secretary of the Senate on January 21, 2020. Without objection, the foregoing documents will be printed in the congressional record. I note the presence in the House of the Senate, in the Senate chamber, of the managers on the part of the House of Representatives and counsel for the President of the United States.
Mr. Chief Justice.
The Majority Leader is recognized.
I send to the desk a list of floor privileges for closed sessions. It's been agreed to by both sides. I ask that it be inserted in the record and agreed to by unanimous consent.
Without objection.
For the further information of all senators, I'm about to send a resolution to the desk providing for an outline of the next steps in these proceedings. It will be debatable by parties for 2 hours, equally divided. Senator Schumer will then send an amendment to the resolution to the desk. Once that amendment has been offered and reported, we'll have a brief recess. When we reconvene, Senator Schumer's amendment will be debatable by the parties for 2 hours. Upon the use or yielding back of time, I intend to move to table Senator Schumer's amendment. And so, Mr. Chief Justice, I send a resolution to the desk and ask that it be read.
The clerk will read the resolution.
Senate Resolution 483 to provide for related procedures concerning the articles of impeachment against Donald John Trump, President of the United States. Resolved that the House of Representatives shall file its record with the Secretary of the Senate, which will consist of those publicly available materials that have been submitted to or produced by the House Judiciary Committee, including transcripts of public hearings or markups and any materials printed by the House of Representatives or the House Judiciary Committee pursuant to House Resolution 660. Materials in this record will be admitted into evidence subject to any hearsay, evidentiary, or other objections that the President may make after opening presentations are concluded. All materials filed pursuant to this paragraph shall be printed and made available to all parties. The President and the House of Representatives shall have until 9 a.m. on Wednesday, January 22nd, 2020, to file any motions permitted under the rules of impeachment, with the exception of motions to subpoena witnesses or documents or any other evidentiary motions. Responses to any such motions shall be filed no later than 11 a.m. on Wednesday, January 22nd, 2020. All materials filed pursuant to this paragraph shall be filed with the Secretary and be printed and made available to all parties. Arguments on such motions shall begin at 1 p.m. on Wednesday, January 22nd, 2020, and each side may determine the number of persons to make its presentation, following which the Senate shall deliberate, if so ordered, under the impeachment rules, and vote on any such motions. Following the disposition of such motions, or if no motions are made, then the House of Representatives shall make its presentation in support of the articles of impeachment for a period of time not to exceed 24 hours over up to 3 session days. Following the House of Representatives' presentation, the President shall make his presentation for a period not to exceed 24 hours over up to 3 session days. Each side may determine the number of persons to make its presentation. Upon the conclusion of the President's presentation, senators may question the parties for a period of time not to exceed 16 hours. Upon the conclusion of questioning by the Senate, there shall be 4 hours of argument by the parties, equally divided, followed by deliberation by the Senate, if so ordered under the impeachment rules, on the question of whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. The Senate, without any intervening action, motion, or amendment, shall then decide by the yeas and nays whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. Following the disposition of that question, other motions provided under the impeachment rules shall be in order. If the Senate agrees to allow either the House of Representatives or the President to subpoena witnesses, the witnesses shall first be deposed, and the Senate shall decide after deposition which witnesses shall testify pursuant to the impeachment rules. No testimony shall be admissible in the Senate unless the parties have had an opportunity to depose such witnesses. At the conclusion of deliberations by the Senate shall vote on each article of impeachment.
The resolution is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent of this motion?
Managers are in opposition to this resolution.
Thank you. Mr. Cipollone, are you a proponent or opponent of the motion?
Mr. Chief Justice, we are a proponent of the motion.
Then, Mr. Cipollone, your side may proceed first, and we'll be able to reserve rebuttal time if you wish.
Thank you, Mr. Chief Justice. Majority Leader McConnell, Democratic Leader Schumer, Senators. My name is Pat Cipollone. I am here as counsel to the President of the United States. Our team is proud to be here representing President Trump. We support this resolution. It is a fair way to proceed with this trial. It is modeled on the Clinton resolution, which had 100 senators supporting it the last time this body considered an impeachment. It requires the House managers to stand up and make their opening statement and make their case. They have delayed bringing this impeachment to this House for 33 days to this body. And it's time to start with this trial. It's a fair process. They will have the opportunity to stand up and make their opening statement. They will get 24 hours to do that. Then the president's attorneys will have a chance to respond. After that, all of you will have 16 hours to ask whatever questions you have of either side. Once that's finished and you have all of that information, we will proceed to the question of witnesses and some of the more difficult questions that will come before this body. We are in favor of this. We believe that once you hear those initial presentations, the only conclusion will be that the president has done absolutely nothing wrong, and that these articles of impeachment do not begin to approach the standard required by the Constitution, and in fact, they themselves will establish nothing beyond those articles. You look at those articles alone and you will determine that there is absolutely no case. So we respectfully ask you to adopt this resolution so that we can begin with this process. It is long past time to start this proceeding, and we are here today to do it. And we hope that the House managers will agree with us and begin this proceeding today. We reserve the remainder of our time for rebuttal.
Mr. Chief Justice, Senators, and Counsel for the President, the House managers, on behalf of the House of Representatives, rise in opposition to Leader McConnell's resolution. Let me begin by summarizing why. Last week, we came before you to present the articles of impeachment against the President of the United States for only the third time in our history. Those articles charge President Donald John Trump with abuse of power and obstruction of Congress. The misconduct set out in those articles is the most serious ever charged against a president. The first article, abuse of power, charges the president with soliciting a foreign power to help him cheat in the next election. Moreover, it alleges, and we will prove, that he sought to coerce Ukraine into helping him cheat by withholding official acts, two official acts: a meeting that the new president of Ukraine desperately sought with President Trump at the White House to show the world, and the Russians in particular, that the Ukrainian president had a good relationship with his most important patron, the President of the United States. And even more perniciously, President Trump illegally withheld almost $400 million in taxpayer-funded military assistance to Ukraine, a nation at war with our Russian adversary, to compel Ukraine to help him cheat in the election. Astonishingly, the president's trial brief filed yesterday contends that even if this conduct is proved, that there is nothing that the House or this Senate may do about it. It is the president's apparent belief that under Article 2, he can do anything he wants, no matter how corrupt, outfitted in gaudy legal clothing. And yet, when the founders wrote the impeachment clause, they had precisely this type of misconduct in mind. Conduct that abuses the power of his office for personal benefit, that undermines our national security, that invites foreign interference in our democratic process of an election. It is the trifecta of constitutional misconduct justifying impeachment. In Article 2, the president is charged with other misconduct that would likewise have alarmed the founders: the full, complete, and absolute obstruction of a co-equal branch of government, the Congress, during the course of its impeachment investigation into the president's own misconduct. This is every bit as destructive of our constitutional order as the misconduct charged in the first article. If a president can obstruct his own investigation, if he can effectively nullify a power the Constitution gives solely to Congress, indeed the ultimate power the Constitution gives to prevent presidential misconduct, then the president places himself beyond accountability, above the law, cannot be indicted, cannot be impeached. It makes him a monarch, the very evil against which our Constitution and the balance of powers it carefully laid out was designed to guard against. Shortly, the trial on these charges will begin, and when it has concluded, you'll be asked to make several determinations. Did the House prove that the president abused his power by seeking to coerce a foreign nation to help him cheat in the next election? And did he obstruct the Congress in its investigation into his own misconduct by ordering his agencies and officers to cooperate
refuse to cooperate in any way, to refuse to testify, to refuse to answer subpoenas for documents, and through every other means. And if the House has proved its case, and we believe the evidence will not be seriously contested, you will have to answer at least one other critical question. Does the commission of these high crimes and misdemeanors require the conviction and removal of the president? We believe that it does, and that the Constitution requires that it be so, or the power of impeachment must be deemed a relic or a casualty to partisan times, and the American people left unprotected against a president who would abuse his power for the very purpose of corrupting the only other method of accountability, our elections themselves. And so you will vote to find the president guilty or not guilty, to find his conduct impeachable or not impeachable. But I would submit to you, these are not the most important decisions you will make. How can that be? How can any decision you will make be more important than guilt or innocence, than removing the president or not removing the president? I believe the most important decision in this case is the one you will make today. The most important question is the question you must answer today. Will the president and the American people get a fair trial? Will there be a fair trial? I submit that this is an even more important question than how you vote on guilt or innocence, because whether we have a fair trial will determine whether you have a basis to render a fair and impartial verdict. It is foundational, the structure upon which every other decision you will make must rest. If you only get to see part of the evidence, if you only allow one side or the other a chance to present their full case, your verdict will be predetermined by the bias in the proceeding. If the defendant is not allowed to introduce evidence of his innocence, it's not a fair trial. So too for the prosecution. If the House cannot call witnesses or introduce documents and evidence, it's not a fair trial. It's not really a trial at all. Americans all over the country are watching us right now. And imagine they're on grand jury or they're on jury duty. Imagine that the judge walks into that courtroom and says that she's been talking to the defendant. And at the defendant's request, the judge has agreed not to let the prosecution call any witnesses or introduce any documents. The judge and the defendant have agreed that the prosecutor may only read to the jury the dry transcripts of the grand jury proceedings. That's it. Has anyone on jury duty in this country ever heard a judge describe such a proceeding and call it a fair trial? Of course not. That's not a fair trial. It's a mockery of a trial. Under the Constitution, this proceeding, the one we are in right now, is the trial. This is not the appeal from a trial. You are not appellate court judges. Okay, one of you is. And unless this trial is going to be different from every other impeachment trial or any other kind of trial for that matter, you must allow the prosecution and defense, the House manager and the president's lawyers, to call relevant witnesses. You must subpoena documents that the president has blocked, but which bear on his guilt or innocence. You must impartially do justice as your oath requires. So what does a fair trial look like in the context of impeachment? The short answer is it looks like every other trial. First, the resolution should allow the House managers to obtain documents that have been withheld. First, not last, because the documents will inform the decision about which witnesses are most important to call. And when the witnesses are called, the documentary evidence will be available and must be available to question them with. Any other order makes no sense. Next, the resolution should allow the House managers to call their witnesses. And then the president should be allowed to do the same and any rebuttal witnesses. And when the evidentiary portion of the trial ends, the parties argue the case. You deliberate and render a verdict. If there's a dispute as to whether a particular witness is relevant or material to the charges brought, under the Senate rules, the Chief Justice would rule on the issue of materiality. Why should this trial be different than any other trial? The short answer is it shouldn't. But Leader McConnell's resolution would turn the trial process on its head. His resolution requires the House to prove its case without witnesses, without documents, and only after it's done will such questions be entertained, with no guarantee that any witnesses or any documents will be allowed even then. That process makes no sense. So what is the harm of waiting until the end of the trial, of kicking the can down the road on the question of documents and witnesses? Besides the fact it's completely backwards, trial first, then evidence, besides the fact that the documents would inform the decision on which witnesses and help in their questioning, the harm is this: you will not have any of the evidence the president continues to conceal throughout most or all of the trial. And although the evidence against the president is already overwhelming, you may never know the full scope of the president's misconduct or those around him. And neither will the American people. The charges here involve the sacrifice of our national security at home and abroad, and a threat to the integrity of the next election. If there are additional remedial steps that need to be taken after the president's conviction, the American people must know about it. But if, as a public already jaded by experience has come to suspect, this resolution is merely the first step of an effort orchestrated by the White House to rush the trial, hide the evidence, and render a fast verdict, or worse, a fast dismissal, to make the president's go away as quickly as possible, to cover up his misdeeds, then the American people will be deprived of a fair trial and may never learn just how deep the corruption of this administration goes, or what other risks to our security and elections remain hidden. The harm will also endure for this body. If the Senate allows the president to get away with such extensive obstruction, it will affect the Senate's power of subpoena and oversight just as much as the House. The Senate's ability to conduct oversight will be beholden to the desires of this president and future presidents, whether he or she decides they want to cooperate with a Senate investigation or another impeachment inquiry and trial. Our system of checks and balances will be broken. Presidents will become accountable. In a moment, I will introduce House Manager Lofgren of California to respond on the amendment. Leader McConnell has already got the votes to pass. But I did want to take this opportunity before certain representations became congealed to respond to my colleague's argument on the resolution at large. First, it's worth noting they said nothing about the resolution. They said nothing about the resolution. They made no effort to defend it. They made no effort to even claim that this was like the Senate trial in the Clinton proceeding. They made no argument that, well, this is different here because of this or that, or they made no argument about that whatsoever. They made no argument that it makes sense to try the case and then consider documents. They made no argument about why it makes sense to have a trial without witnesses. And why? Because it's indefensible. It's indefensible. No trial in America has ever been conducted like that. And so you heard nothing about it. And that should be the most telling thing about counsel's argument. They had no defense of the McConnell resolution because there is none. They couldn't defend it on the basis of Senate precedent. They couldn't defend it on the basis of Senate history, tradition. They couldn't defend it on the basis of the Constitution. They couldn't defend it at all. And so what did they say? Well, first they made the representation that the House is claiming there is no such thing as executive privilege. That's nonsense. No one here has ever suggested there's no such thing as executive privilege. But the interesting thing here is they've never claimed executive privilege. Not once during the House investigation did they ever say that a single document was privileged or a single witness had something privileged to say. And why didn't they invoke privilege? Why only now? And even now they haven't quite invoked it. Why only now? Why not in the House? Because in order to claim privilege, as they know because they're good lawyers, you have to specify which document, which line, which conversation, and they didn't want to do that because to do that, the president would have to reveal the evidence of his guilt. That's why they made no invocation of privilege. Now, they make the further argument that the House should only be able to impeach after they exhaust all legal remedies, as if the Constitution says the House shall have the sole power of impeachment, asterisk, but only after it goes to court, in the district court, then the Court of Appeals, and then en banc, and then the Supreme Court, and it's remanded, and they go back up the chain, and it takes years. Why didn't the founders require the exhaustion of legal remedies? Because they didn't want to put the impeachment process in the courts. And you know what's interesting is that while these lawyers for the president are here before you today saying the House should have gone to court, they are in court saying the House may not go to court to enforce its subpoenas. I kid you not. Other lawyers, maybe not the ones at this table, but other lawyers for the president are in court saying the exact opposite of what they're telling you today. They're saying you cannot enforce congressional subpoenas. That's non-judiciable. You can't do it. Counsel brings up the case involving Charles Kupperman, who was a deputy to John Bolton on the National Security Council, and says he did what he should do. He went to court to fight us. Well, the Justice Department took the position he can't do that. So these lawyers are saying he should, and those lawyers are saying he shouldn't. They can't have it both ways. Now, interestingly, while Dr. Kupperman went to court, and they applaud him for doing that, his boss, John Bolton, now says there's no necessity for him to go to court. He doesn't have to do it. He's willing to come and talk to you. He's willing to come and testify and tell you what he knows. The question is, do you want to hear it? Do you want to hear it? Do you want to hear from someone who was in the meetings, someone who described what the president did, this deal between Mulvaney and Sondland as a drug deal? Do you want to know why it was a drug deal? Do you want to ask him why it was a drug deal? Do you want to ask him why he repeatedly told people, go talk to the lawyers? You should want to know. They don't want you to know. They don't want you to know. The president doesn't want you to know. Can you really live up to the oath you've taken to be impartial and not know? I don't think you can. Now, they also made the argument that you'll hear more later on from apparently Professor Dershowitz that, well, abuse of power is not an impeachable offense. It's interesting that they had to go outside the realm of constitutional lawyers and scholars to a criminal defense lawyer to make that argument because no reputable constitutional law expert would do that. Indeed, the one they called in the House, the Republicans called in the House, Jonathan Turley, has said exactly the opposite. There's a reason that Jonathan Turley is not sitting at the table, much to his dismay, and that is because he doesn't support their argument. So they'll cite him for one thing, but they'll ignore him for the other. Now they say, oh, the president is very transparent. He may have refused every subpoena, every document request, but he released two documents. The document on the July 25th call and the document on the April 21st call. Well, let's face it. He was forced to release the record of the July 25th call when he got caught. When a whistleblower filed a complaint, when we opened an investigation, he was forced because he got caught. You don't get credit for transparency when you get caught. And what's more, what's revealed in that, of course, is damning. Now they point to the only other record he has apparently released, the April 21st call, and that's interesting too. Now that's just a congratulatory call, but what's interesting about it is the president was urged on that call to bring up the issue of corruption. And indeed, in the readout of that call, the White House misleadingly said he did. But now that we've seen the record, we see that he didn't. And notwithstanding counsel's claim in their trial brief that the president raised the issue of corruption in his phone call, the July 25th call, of course, that word doesn't appear in either conversation. And why? Because the only corruption he cared about was the corruption that he could help bring about. Now, Mr. Cipollone made the representation that Republicans were not even allowed in the depositions conducted in the House. Now, I'm not going to suggest to you that Mr. Cipollone would deliberately make a false statement. I will leave it to Mr. Cipollone to make those allegations against others. But I will tell you this, he's mistaken. He's mistaken. Every Republican on the 3 investigative committees was allowed to participate in the depositions, and more than that, they got the same time we did. You show me another proceeding, another presidential impeachment or other that had that kind of access for the opposite party. Now, there were depositions in the Clinton impeachment. There were depositions in the Nixon impeachment. So what they would say is some secret process. Well, there were the same private depositions in these other impeachments as well. Finally, a couple last points. They make the argument the president was not allowed in the Judiciary Committee, chaired by my colleague, Chairman Nadler, to be present, to present evidence, to have his counsel present. That is also just plain wrong. Just plain wrong. I'm not going to suggest to you they're being deliberately misleading here, but it is just plain wrong. You've also heard my friends at the other table make attacks on me and Chairman Nadler. You'll hear more of that. I'm not going to do them the dignity of responding to them, but I will say this. They make a very important point, although it's not the point I think they're trying to make. When you hear them attack the House managers, what you're really hearing is, we don't want to talk about the president's guilt. We don't want to talk about the McConnell resolution and how patently unfair it is. We don't want to talk about how pardon the expression, ass backwards it is to have a trial and then ask for witnesses. And so we'll attack the House managers because maybe we can distract you for a moment from what's before you. Maybe if we attack the House managers, you'll be thinking about them instead of thinking about the guilt of the president. So you'll hear more of that, and every time you do, every time you hear them attacking the House managers, I want you to ask yourselves, away from what issue are they trying to distract me? What was the issue that came up just before this? What are they trying to deflect my attention from? Why don't they have a better argument to make on the merits? Finally, Mr. Sekulow asks, why are we here? Why are we here? Well, I'll tell you why we're here. Because the president used the power of his office to coerce an ally at war with an adversary, at war with Russia, use the power of his office to withhold hundreds of millions of dollars of military aid that you appropriated and we appropriated to defend an ally and defend ourselves because it's our national security as well. And why? To fight corruption? That's nonsense, and you know it. He withheld that money, and he withheld even meeting with him in the Oval Office, the president of Ukraine, because he wanted to coerce Ukraine into these sham investigations of his opponent that he was terrified would beat him in the next election. That's what this is about. You want to say that's okay? Their brief says that's okay. The president has a right to do it. On Article 2, we heard the president, he can do whatever he wants. You want to say that's okay? Then you got to say that every future president can come into office and they can do the same thing. Are we prepared to say that? Well, that's why we're here. I now yield to Representative Lofgren.
Mr. Chief Justice, Senators, Counsel for the President, the House managers strongly support Senator Schumer's amendment, which would ensure a fair, legitimate trial based on a full evidentiary record. The Senate can remedy President Trump's unprecedented cover-up by taking a straightforward step. It can ask for the key evidence that the president has improperly blocked. Senator Schumer's amendment does just that. The amendment authorizes a subpoena for White House documents that are directly relevant to this case. These documents focus on the president's scheme to strong-arm Ukraine to announce an investigation into his political opponent to interfere with the 2020 election. The documents will reveal the extent of the White House's coordination with the president's agents, such as Ambassador Sondland and Rudy Giuliani, who pushed the president's so-called drug deal on Ukrainian officials. The documents will also show us how key players inside the White House, such as the president's acting chief of staff, Mick Mulvaney, and his deputy, Robert Blair, helped set up the deal by executing the freeze on all military aid and withholding a promised visit to the White House. The documents include records of the people who may have objected to this scheme, such as Ambassador Bolton. This is an important impeachment case against the president. The most important documents are going to be at the White House. The documents Senator Schumer's amendment targets would provide more clarity and context about President Trump's scheme. The amendment prevents the president from hiding evidence, as he has previously tried to do. Now, the House subpoenaed these documents as part of the impeachment inquiry, but the president completely rejected this in every document subpoena from the House. As powerful as our evidence is, and make no mistake, it overwhelmingly proves his guilt. We did not receive a single document from the executive branch agency, including the White House itself. Recent revelations from press reports, Freedom of Information Act requests, and additional witnesses, such as Lev Parnas, underscore how relevant these documents and therefore why the president has been so desperate to hide them and his misconduct from Congress and from the American people. A trial without all the relevant evidence is not a fair trial. It would be wrong for you senators acting as judges to be deprived of relevant evidence of the president's offenses when you are judging these most serious charges. It would also be unfair to the American people who overwhelmingly believe the president should produce all relevant documents and evidence. Now, documentary evidence is used in all trials for a simple reason. As the story goes, the documents don't lie. Documents give objective, real-time insight into the events under investigation. The need for such evidence is especially important in Senate impeachment trials. More than 200 years of Senate practice outside of a trial. We don't know with certainty what the documents will say. We simply want the truth, whatever that truth may be. So do the American people. They want to know the truth, and so should everybody in this chamber, regardless of our party affiliation. There are key reasons why this amendment is necessary. We'll begin by walking through the history and precedent of Senate impeachment trials. I'll let you know about the House's efforts to get the documents, which were met by the president and his administration's categorical commitment to hide all the evidence at all costs. And we'll address the specific need for these subpoenaed White House documents. I'll tell you why these documents are needed now, not at the end of the trial, in order to ensure a full, fair trial based on a complete evidentiary record. Now, some have suggested incorrectly that the Senate is limited only to evidence gathered before the House approved its articles of impeachment. Others have suggested, also incorrectly, that it would somehow be strange for the Senate to issue subpoenas. These claims are without any historical, precedential, or legal support. Over the past 2 centuries, the Senate has always understood that its sole power under the Constitution to try all impeachments requires the Senate to sit as a court of impeachment and hold a trial. In fact, the founders assigned sole authority only twice in the Constitution. First, giving the House sole authority to impeach, and second, giving the Senate sole authority to try that impeachment. If the founders had intended for the Senate to serve as some kind of appellate body, they would have said that. But no, instead they wrote this. Article 1, Section 3, the Senate shall have the sole power to try all impeachments. The Senate has always received the relevant documents in impeachment trials, and indeed, the Senate's own rules of procedure and practice make clear that new evidence will be considered. Precedent shows this. All 15 full Senate impeachment trials considered new evidence. Let's look at a few examples that show the Senate takes new evidence in impeachment trials. The first ever presidential impeachment trial in 1868 against President Andrew Johnson allowed the House managers to spend the first 2 days of the trial introducing new documentary evidence. It was the same in Judge John Pickering's trial in 1804. New documents were presented to the Senate nearly a week before House managers made their opening statement and later throughout the trial. And, as been mentioned earlier by Mr. Schiff, in modern times, in 2010, George Porteous's impeachment trial included 7 months of pretrial discovery and 6,000 pages of documentary evidence admitted at trial. After that evidence was admitted, the Senate held its trial. President Clinton's case did not involve subpoenas for documents. Now, why was that? Because President Clinton had already produced a huge trove of documents. The independent counsel turned over to Congress some 90,000 pages of relevant documents gathered during the course of his years-long investigation. And I remember, as a member of the Judiciary Committee, going over to the Ford building, looking at the boxes of the document. But even with all those documents, the Clinton trial included the opportunity to present new evidence and the admission of additional documents and 3 witnesses. The Clinton impeachment precedent also shows how President Trump's refusal to produce any relevant documents in response to congressional subpoenas is different than past presidents, different from President Clinton, different from President Johnson, and less even than President Nixon. In short, not a single president has categorically refused to cooperate with an impeachment investigation. Not a single president has issued a blanket direction to his administration to produce no documents and no witnesses. These are the precedents the Senate must rely on. The Senate should issue a subpoena for documents at the very outset of the proceedings so that this body, the House managers, the president, can all account for those documents in their presentations and deliberations. It doesn't make sense to request and receive documents after the parties present their cases. The time is now to do that. So why is the amendment needed to prevent President Trump from continuing his categorical commitment to hide the evidence? In this case, the House sought White House documents. Why don't we have them? It's not because we didn't try. It's because the White House refused to give them to us. The president's defense team seems to believe that the White House is permitted to completely refuse to provide any documents without regard to whether or not it is privileged. They apparently believe that Congress's authority is subject to the approval of the president. But that's not what the Constitution says. Our Constitution sets forth a democracy with a system of checks and balances to ensure that no one, and certainly not the president, is above the law. Now, even President Nixon produced more than 30 transcripts of White House recordings and notes from meetings with the president. Here, even before the House launched the investigation that led to this trial, President Trump rejected Congress's constitutional responsibility to use its lawful authority to investigate his actions. He asserted that his administration was fighting all the subpoenas, proclaiming, "I have an Article 2, where I have the right to do whatever I want as president." Here is what he said.
Then I have an Article 2, where I have the right to do whatever I want as president.
Even after the House formally announced its investigation of the president's conduct in Ukraine, the president still continued his obstruction. Beginning on September 9th, 2019, the House investigative committees made 2 attempts to voluntarily obtain documents from the White House. The White House refused to engage with, frankly, or even respond to the House committees. On October 4th, the House Committee on Oversight and Reform set a subpoena to White House Acting Chief of Staff Mick Mulvaney, this time compelling the production of documents from the White House by October 18th. On October 8th, before the White House documents were due, the White House counsel sent a letter to Speaker Pelosi stating the president's position that The President Trump and his administration cannot participate in this partisan inquiry under these circumstances. The president simply declared that he will not participate in an investigation he didn't like. 10 days later, on October 18th, the White House counsel sent a letter to the House confirming that it would continue to stonewall. The White House counsel again stated the president refused to participate. Well, the Constitution, Article 1, Section 2, says that the House shall have the sole power of impeachment, just as in Article 1, Section 3, the Senate has the sole power to try. Participation in a duly authorized congressional investigation isn't optional. It's not up to the president to decide whether to participate or not. The Constitution gives the House the sole power of impeachment. It gives the Senate the sole power to try all impeachments. The president may not like being impeached, but if the president, not the Congress, decides when impeachment proceedings are appropriate, then the impeachment power is no power at all. And if you let him block from Congress and from the American people the evidence to cover up his offenses, then the impeachment power truly will be meaningless. With all the back and forth about these documents, we've heard the phrase executive privilege. The president and his lawyers keep saying it. They talk about vast legal rights to justify hiding the truth, withholding information, but that's a distraction. That's not what the Constitution provides, and the truth is, as has been mentioned by Mr. Schiff, in the course of the entire impeachment inquiry, President Trump has not once asserted executive privilege, not a single time. It was not the reason provided by Mr. Cipollini for refusing to comply with the House's subpoena. Indeed, President Trump didn't offer legal justification for withholding the evidence. Here's the truth. Presidents, members of Congress, judges, and the Supreme Court have recognized throughout our nation's history that Congress's investigative power are at their absolute peak during impeachment proceedings. Your powers. Executive privilege cannot be a barrier to give absolute secrecy to cover up wrongdoing. If it did, the House and the Senate would see their power disappear. When President Nixon tried that argument by refusing to produce tape recordings to prosecutors and to Congress, he was soundly rebuked by the other two branches of government. The Supreme Court unanimously ruled against him. The House Judiciary Committee voted that he be impeached for obstruction of Congress. It would be remarkable for the United States Senate to declare, for the first time in our nation's history, that the president has an absolute right to decide whether his own impeachment trial is legitimate. And it would be extraordinary for the Senate to refuse to seek important documentary evidence, especially when the president has yet to assert any privilege to justify withholding documents. Now, there's another reason this amendment is important. The documents sought are directly relevant to the president's misconduct. The White House is concealing documents involving officials who have direct knowledge of key events at the heart of this trial. This isn't just a guess. We know these documents exist from the witnesses who testified in the House and from other public release of documents. And let's walk through those specific documents that the White House should send to the Senate. They include, among other documents, relating to President Trump's direct communications with President Zelensky, President Trump's request for political investigations, including communications with Rudy Giuliani, Ambassador Sondland, and others, President Trump's unlawful hold of the $391 million of military aid, concerns that White House officials reported to NSC legal counsel in real time, the president's decision to recall Ambassador Marie Yovanovitch from Ukraine. The first set of documents the Senate should get about President Trump's communication with the president of Ukraine would include the phone calls on April 21st and July 25th, as well as the September 25th, 2019 meeting with President Zelensky in New York. We know, for example, that NSC officials prepared talking points for the president in preparation for both calls with the Ukrainian president. The talking points were about American policy as reflected by the votes of Congress as well as the Trump administration itself. They didn't include any mention of the Bidens or the 2016 election interference or investigations that President Trump requested on the July 25th call. Here's a clip of Lieutenant Colonel Vindman explaining how the president ignored the points about American policy, reflecting the views of both the Congress and the Trump administration.
Colonel Vindman, if I could turn your attention to the April 21st call, that is the first call between President Trump and President Zelensky. Did you prepare talking points for the president to use during that call?
Yes, I did.
And did those talking points include rooting out corruption in Ukraine?
Yes.
That was something the president was supposed to raise in the conversation with President Zelensky?
Those were the recommended talking points that were cleared through the NSC staff for the president, yes.
The materials provided for the July 25th call that Lieutenant Colonel Vindman mentioned are highly relevant. They could help confirm that the president's actual statements to President Zelensky were unrelated to the foreign policy objectives of his own administration and show that they served his own personal interests at the expense of America's national security interests. These documents also include handwritten notes and other documents that White House officials generated during the calls and meetings. We know, for example, that Lieutenant Colonel Vindman, Mr. Morrison, Jennifer Williams, all testified to taking contemporaneous handwritten notes during the July 25th call. Ms. Williams and Lieutenant Colonel Vindman both testified that President Zelensky made an explicit reference to Burisma that was not included in the memorandum that the White House released to the public. Here's a clip of their testimony.
Both of you recall President Zelensky in that conversation raising the issue or mentioning Burisma, do you not?
That's correct.
Correct.
And yet, the word Burisma appears nowhere in the call record that's been released to the public. Is that right?
That's right.
Correct.
Why do you need documents generated after the calls and meetings? They would shed light on how these events were perceived in the White House and what actions were taken moving forward. For example, National Security Advisor John Bolton wasn't on the 25th call, but he was apparently informed about the contents of the call afterward. His reaction, once he was informed, would be helpful to understanding the extent to which President Trump's action deviated from American policy and American security interests. There's another set of documents that the Senate should get, and they relate to the political investigations that President Trump and his agents repeatedly asked Ukrainian officials to announce. These documents about efforts to pressure Ukraine to announce investigations and the decision to place a hold on military aid to Ukraine, they would be very important for you to evaluate the president's conduct. For example, Ambassador Bolton is a first-hand witness to President Trump's abuse of power. He reported directly to the president. He supervised the entire staff of the National Security Council. Public reports indicate that John Bolton is a voracious note-taker in every meeting. From witness testimony, we know that Ambassador Bolton hosted the July 10th 2019 meeting where Ambassador Sondland told Ukrainian officials that the promised White House meeting would be scheduled if they announced the investigations. We know Bolton was briefed about this meeting immediately following it when Ambassador Sondland said he had a deal with Mick Mulvaney to schedule the promised White House meeting if Ukraine announced investigations into the Bidens in the 2016 election. We also know Ambassador Bolton was involved in briefing the president on a presidential decision memorandum in August, reflecting the consensus interagency opinion that Ukrainian security assistance was vital to America's national security, something the Congress had approved, appropriated, something the president had signed. Press reports indicate that he too was involved in a late August Oval Office meeting where he, Secretary Pompeo, and Secretary Esper all tried to convince the president to release the aid. Now, Ambassador Bolton has come forward and publicly confirmed that he was a witness to important events, but also that he has new evidence that no one has seen yet. If we know there is evidence that's not yet come out, all of us should want to hear it. We should want to hear it now, before Ambassador Bolton testifies. We should get documents and records relating to his testimony, including his notes, which would provide contemporaneous evidence about what was discussed in meetings related to Ukraine, which would help to evaluate his testimony. The evidence is not just restricted to Ambassador Bolton. During his public testimony, Ambassador Gordon Sondland stated, "I have not had access to all my phone records." He also said that he and his lawyers had asked repeatedly for these materials. He said the materials would help refresh his memory. We should look at that material. Ambassador Sondland also testified that he exchanged a number of emails with top officials like Mick Mulvaney about his efforts to pressure Ukraine to announce the investigations President Trump demanded. Here's his testimony.
Third, let me say, precisely because we did not think that we were engaging in improper behavior, we made every effort to ensure that the relevant decision makers at the National Security Council and the State Department knew the important details of our efforts. The suggestion that we were engaged in some irregular or rogue diplomacy is absolutely false. I have now identified certain State Department emails and messages that provide contemporaneous support for my view. These emails show that the leadership of the State Department, the National Security Council, and the White House were all informed about the Ukraine efforts from May 23rd, 2019, until the security aid was released on September 11th, 2019.
These emails, among others, are in the possession of... These emails referenced in this testimony are in the possession of the White House, the State Department, and even the Department of Energy, since officials from all three entities communicated together. You know, during his testimony, Ambassador Sondland described it this way. Everyone was in the loop. It was no secret. These emails are therefore important to understanding the full scope of the scheme. The request for relevant evidence is not confined to Trump administration officials. The Senate should also get White House records relating to the president's private agents who acted on his behalf in Ukraine, including Rudy Giuliani, Victoria Tenzing, and Joe DeGeneva. Witness testimony and documents have made clear that Mr. Giuliani, a frequent visitor to the White House who also received and made frequent calls to the White House, was acting on behalf of the president to press Ukrainian officials to announce investigations that would personally and politically benefit the president. For example, the May 10th, 2019 letter from Mr. Giuliani to President-elect Zelensky that's shown on this slide states he was acting, quote, as personal counsel to President Trump with his knowledge and consent. He requested a meeting with the president-elect and he to be joined by Ms. Tenzing, who is, quote, very familiar with this matter. The evidence indicates he was collaborating with Ms. Tenzing and Mr. DeGeneva in this effort. The Senate should get the White House records of meetings, of calls involving Mr. Giuliani, Ms. Tenzing, or Mr. DeGeneva. These records are important to help you understand the extent to which the White House was involved in Mr. Giuliani's efforts to coerce Ukraine to announce the investigations the president wanted. The records would also show how the president's personal political agenda became more important than policies to help America's national security interests. The President's Counsel may, consistent with his prior attempts to hide evidence, assert that attorney-client privilege would cover these documents. But the President's personal attorney-client privilege cannot shield evidence of misconduct in office, or that of his aides, or of his lawyers' participation in corrupt schemes. We aren't asking for documents reflecting legitimate legal advice. You need documents about their actions to pressure Ukraine to announce an investigation into President Trump's political opponent. There's a set of White House documents that relate directly to the president's unlawful decision to withhold $391 million appropriated bipartisan to help Ukraine. Witnesses have testified that President Trump directly ordered a hold on this security assistance, despite the unanimous opinion of his agencies that the aid should be released. Importantly, according to the Government Accountability Office, his action violated the law. On January 16, 2020, the GAO, an independent watchdog, issued a legal opinion finding that President Trump violated the law when he held up security assistance to Ukraine. The GAO said, and I quote, "Faithful execution of the law does not permit the president to substitute his own policy priorities for those that Congress enacted into law. OMB withheld funds for a policy reason which is not permitted under the Impoundment Control Act. The withholding was not a programmatic delay. Therefore, we conclude that OMB violated the ICA. The fact that the president's action to freeze the aid, which he used to pressure Ukraine to announce the political investigations he wanted, was against not only the official consensus of his own administration, but also against the law, and it was to help himself. That helps demonstrate these actions were taken for President Trump's personal and political benefit. Witness testimony and public reporting make clear the White House has a significant body of documents that relate to these key aspects of the president's scheme. Some of these documents outline the planning of the president's freeze. For example, the New York Times reported in June that Mr. Mulvaney emailed his senior advisor, Mr. Blair, "Did we ever find out about the money for Ukraine and whether we can hold it back?" This shows that Mr. Mulvaney was in email contact with his aides about the very issues under investigation as part of this impeachment. It tells us that the White House is in possession of communications that go to the heart of the charges before you. The Senate should also get materials prepared for summary notes from a late August meeting with President Trump, Secretary of Defense Mark Esper, and Secretary of State Mike Pompeo when they tried to convince the president that freeing, and this is a quote, "freeing up the money for Ukraine was the right thing to do." According to the New York Times, Ambassador Bolton told the president, "This is in America's interest." The Senate should review that highly relevant document, which reflects real-time assertions by President Trump's own senior aides that Ukrainian aid was in the national security interest of the United States and that there was no legitimate reason to hold up the aid. There are documents that include after-the-fact justifications to try and overcome legal problems and the unanimous objections to freezing assistance to Ukraine. And we know these documents exist. For example, on January 3rd, 2020, OMB stated in a letter to the New York Times that it had discovered 20 responsive documents consisting of 40 pages, reflecting emails between White House official Robert Blair and OMB official Michael Duffy that relate directly to the freezing of the Ukraine security assistance. But OMB wouldn't release them in a Freedom of Information lawsuit, and they have refused to produce these documents at the direction of the president in response to the House's lawful subpoena. Now, the Washington Post reported that a confidential White House review of President Trump's decision to hold up hundreds of documents that reveal extensive efforts to generate an after-the-fact justification for the debate over whether the delay was legal. That's known as a cover-up, actually. The White House lawyers had apparently uncovered, quote, early August email exchanges between Acting Chief of Staff Mick Mulvaney and White House budget officials seeking to provide some explanation for withholding the funds the president had already ordered on hold. The documents also reportedly include communications between White House officials and outside agencies. Not only does Congress have a right to see them, the public does too, under Freedom of Information laws. Now, as a matter of constitutional authority, the Senate has the greatest interest in and right to compel those documents. Indeed, as the news article explains, White House lawyers are reportedly, quote, worried about unflattering exchanges and facts that could, at a minimum, embarrass the president. Perhaps they should be worried about that. But the risk of embarrassment cannot outweigh the constitutional interests in this impeachment proceeding. Any evidence of guilt, including further proof of the real reason the president ordered the funds withheld, or after-the-fact attempts to paper over knowingly unlawful conduct, they must be provided to ensure a full and fair trial. No privilege or national security rationale can be used as a shield from disclosing misconduct. There are key White House documents relating to multiple instances when White House officials reported their concerns to White House lawyers about the president's scheme to press Ukraine to do the president a domestic political favor. For example, Lieutenant Colonel Vindman and Dr. Hill both informed NSC lawyers about the July 10th meeting in which Ambassador Sondland revealed he had a deal with Mr. Mulvaney. I'm going to go directly to the clip by Dr. Hill, because Dr. Hill, pardon me, at Bolton's direction, also reported that meeting to to John Eisenberg, as she explained in her testimony.
I had a discussion with Ambassador Bolton both after the meeting in his office, a very brief one, and then one immediately afterwards, the subsequent meeting.
So the subsequent meeting, or after both meetings, when you spoke to him and relayed to him what Ambassador Sondland said, what did Ambassador Bolton say to you?
Well, I just want to highlight, first of all, that Ambassador Bolton wanted me to hold back in the room immediately after the meeting. Again, I was sitting on the sofa with a colleague.
Right, but just in that second meeting, what did he say?
Yes, but he was making a very strong point that he wanted to know exactly what was being said. And when I came back and related to him, he had some very specific instruction for me. And I'm presuming that that's
what was that specific instruction?
The specific instruction was that I had to go to the lawyers, to John Eisenberg, our senior counsel for the National Security Council, to basically say, you tell Eisenberg, Ambassador Bolton told me, that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
You relayed everything that you just told us and
I relayed
more?
it precisely, and then the details of how the meeting had unfolded as well, which I gave a full description of this in my October 14 deposition.
There was something wrong going on here, and White House officials were told repeatedly, go tell the lawyers about it. Dr. Hill, Lieutenant Colonel Vindman, Mr. Morrison, who reported to Mr. Eisenberg at least 2 conversations. We need the notes of those documents to find out what was said. And again, attorney-client privilege cannot shield information about misconduct from the impeachment trial of the President of the United States. Now, it's interesting. This amendment is supported by 200 years of precedent. It's needed to prevent the president from continuing to hide the evidence, and that's why the specific documents requested are so important for this case. It's faithful to the Constitution's provision that the Senate shall have the sole power to try all impeachments. The final point I'll make today concerns urgency. The Senate should act on this subpoena now, at the outset of the trial. In 14 of the Senate's 15 full impeachment trials, threshold evidentiary matters, including the timing, nature, and scope of witness testimony and the gathering of all relevant documents, were addressed at the very outset of the trial. There are practical considerations as why the subpoenas need to be issued now. Resolving whether a subpoena should issue now would let us immediately engage with the White House to resolve asserted legitimate privilege issues, if any exist, and ensure you get the documents as soon as possible so they can be presented to the senators in advance of witness testimony. Waiting to resolve these threshold matters until after the parties have presented their case would undercut the process of a genuine, credible trial. Thus, common sense, tradition, and fairness all compel that the amendment should be adopted, and it should be adopted now. Members of the Senate, for all the reasons I walked through today, I urge you to support the amendment to issue a subpoena for White House documents that are directly relevant to evaluating the president's scheme. The House did its job. In the face of the president's obstruction and categorical commitment to hide the evidence, we still gathered direct evidence of his conduct and determined that his conduct required impeachment. The president complains about due process in the House investigation, but he was not only permitted to participate, he was actually required to participate, yet he refused to do so. He refused to provide witnesses and documents that would tell his side of the story. So now it's up to you. With the backing of a subpoena authorized by the Chief Justice of the United States, you can end President Trump's obstruction. If the Senate fails to take this step, if it won't even ask for this evidence, this trial and your verdict will be questioned. Congress and the American people deserve the full truth. There is no plausible reason why anyone wouldn't want to hear all of the available evidence about the president's conduct. It's up to this body to make sure that happens. It's up to you to decide whether the Senate will affirm its sole power and constitutional duty to try impeachments, whether and when it will get the evidence that it needs to render a fair verdict. Don't surrender to the president's stonewalling. It will allow the president to be above the law and deprive the American people of truth in the process. A fair trial is essential in every way. Important for the president, who hopes to be exonerated, not merely acquitted by a trial seen as unfair. Important for the Senate, whose vital role is to continue to protect and defend the Constitution of the United States, which has preserved our American liberty for centuries. And finally, important for the American people, who expect a quest for truth, fairness, and justice. History is watching, and the House managers urge that you support the amendment, and I reserve the balance of my time.
Thank you, Counsel. Mr. Cipollone?
Mr. Chief Justice, Patrick Philbin will present our opposition.
Very well. Mr. Philbin?
Thank you, Mr. Chief Justice, Majority Leader McConnell, Democratic Leader Schumer, Senators. It's remarkable that after taking the action of the breathtaking gravity of voting to impeach the duly elected President of the United States, and after saying for weeks that they had overwhelming evidence to support their case, the first thing that the House managers have done upon arriving finally in this chamber after waiting for 33 days is to say, well, actually, we need more evidence. We're not ready to present our case. We need to have subpoenas and we need to do more discovery because we don't have the evidence we need to support our case. This is stunning. It's a stunning admission of the inadequate and broken process that the House Democrats ran in this impeachment inquiry that failed to compile a record to support their charges. It's stunning that they don't have the evidence they need to present their case and that they don't really have a case. If a litigant showed up in any court in this country on the day of trial and said to the judge, actually, Your Honor, we're not ready to go. We need more discovery. We need to do some more subpoenas. We need to do some more work. They'd be thrown out of court and the lawyers would probably be sanctioned. This is not the sort of proceeding that this body should condone. Now, we've just heard that this is so important. Let's consider what's really at issue in the resolution here and the amendment. It's a matter of timing. It's a matter of when this body will consider whether there should be witnesses or subpoenas for documents. Why is it that the managers, the House managers, are so afraid to have to present their case, remember, they've had weeks of a process that they entirely controlled. They had 17 witnesses who testified first in secret and then in public. They've compiled a record with thousands of pages of reports, and they're apparently afraid to just make a presentation based on the record that they compiled and then have you decide whether there's any there, whether there's anything worth trying to talk to more witnesses about. Why is it that they can't wait a few days to make their presentation on everything they've been preparing for weeks and then have that issue considered? Because they don't think that there is any there, and they want to ram this through now. And they want to ram this through now when it's something that they themselves failed to do. So I want to unpack a couple of the aspects of what they're asking this body to do. Part of it relates to the broken process in the House and how that process was inadequate and invalid and compiled an inadequate record. And part of it has to do with what accepting their request to have this body do their job for them would do to this institution going forward, and how it would alter forever the relationship between the House and the Senate in impeachment proceedings. So first, as to the process in the House, what they're asking, the House manager asking this body to do now is really to do their job for them, because they didn't take the measures to pursue these documents in the House proceedings. And there have been a number of statements made about they tried to get the documents and no executive privilege was asserted and things like that. Let's look at what actually happened. They issued a subpoena to the White House. And the White House explained, and we were told a few minutes ago that the White House provided no response, it provided no rationale. That's not true. In a letter of October 18th, White House counsel Pat Cipollone explained in 3 pages of legal argument why that subpoena was invalid. And that subpoena was invalid because it was issued without authorization. We've heard a lot today about how the Constitution assigns the sole power of impeachment to the House. That's right. That's what Article 1, Section 2 says. It assigns the sole power of impeachment to the House, not to any member of the House. And no committee of the House can exercise that authority to issue subpoenas until it's been delegated that authority by a vote of the House. There was no vote from the House. Instead, Speaker Pelosi held a press conference, and she purported by holding a press conference on September 24th to delegate the authority of the House to Manager Schiff and several other committees and have them issue subpoenas. All of those subpoenas were invalid. And that was explained to the House, to Manager Schiff and the other chairman of those committees at the time in that October 18th letter. Did the House take any steps to remedy that? Did they try to dispute that? Did they go to court? Did they do anything to resolve that problem? No. Because as we know, all that they wanted to do was issue a subpoena and move on. They just wanted to get through the impeachment process as quick as possible and get it done before Christmas. That was their goal. So those subpoenas were unauthorized. Now, what about some of the other things that they brought up? The witnesses. Witnesses who were directed not to testify. And in part on this, we've heard Manager Schiff say several times that the White House never asserted executive privilege. Well, let me be clear on that. That's a lawyer's trick, because it is technically true that the White House didn't assert executive privilege, because there's a particular situation in which you do that in a particular way that you do that. But there's another doctrine of immunity of senior advisors to the president that is based on the same principles as executive privilege, and that has been asserted by presidents of both political parties since the 1970s at least. So that's, and this is what one attorney general explained about that. Quote, "The immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests," end quote. That was Attorney General Janet Reno in the Clinton administration, explaining that senior advisors to the president are immune from congressional compulsion. And that doctrine, that immunity, is rooted in the same principles of executive privilege. It's been asserted by all presidents since the 1970s, and that was the basis on which a number of the advisors whose pictures they put up were directed not to testify. Did they try to challenge that in court? Did they go to court on that one? Did they try to go through the constitutionally mandated accommodations process to see if there was a way to come up with some aspect of testimony could be provided? No, none of that. They just wanted to forge ahead, rush through the process, not have the evidence, and then use that as another charge in their charging sheet for the impeachment, calling it obstruction of Congress. And what that is Professor Turley explained, this idea that when there's a conflict between the executive branch and the House and seeking information, and the president is asserting constitutionally based privileges, that's part of the operation of separation of powers. That is the president's constitutional duty to defend the prerogatives of the office for the future occupants of that office. And it is not something that can be charged as an impeachable offense, as the House Democrats have tried to say here. To do that is an abuse of power. That's what Professor Turley explained. It's Congress's, it's the House Democrats' abuse of power. We just heard Manager Lofgren refer to executive privilege as a distraction. She was asserting that these issues of executive privilege are just a distraction that shouldn't hold things up. But this is what the Supreme Court has said about executive privilege in Nixon versus United States, that the protections for confidentiality and executive privilege are, quote, fundamental to the operations of government and inextricably rooted in the separation of powers under the Constitution, end quote. Inextricably rooted in the separation of powers. That's why it's the president's duty to defend executive branch confidentiality interests, and that is what the president was doing here. Now, the process that they pursued in the House abandoned any effort beyond issuing the first subpoena that was invalid to work out an accommodation with the White House, and instead just tried to rush ahead to have the impeachment done by Christmas. What does that lead to now? They're coming to this body after a process that was half-baked, that didn't compile a record sufficient to support their charges, and asking this body to do their job for them. Now, as Leader McConnell pointed out in some comments earlier today, to allow that, to accept the idea that the House can bring an impeachment here that is not adequately supported, that has not been investigated, that has not got a record to support it, and to turn this body into the investigatory body would permanently alter the relationship between the House and the Senate in impeachment proceedings. It's not the role of the Senate to have to do the House's job for them. It's not the role of the Senate to be doing an investigation and to be doing discovery in a matter like the impeachment of a president of the United States. If the House has not done the investigation and cannot support its case, it's not the time once it arrives here to start doing all that work. That's something that's the House's role. So, this is something that is important for this institution, I believe, not to allow the House to turn it into a situation where this body would have to be doing the House's work for it. If there is not evidence to support the case, if they haven't done their investigation, then they're not going to be able to support their case. Again, what's at issue here, and I think it's important to recall on the issue of this amendment, it's not whether the Senate, whether this body will be considering whether there should be witnesses or not, but when that should be considered. And there is no reason not to take the approach that was done in the Clinton impeachment. 100 senators agreed then that it made sense to hear from both sides before making a determination on that. To hear from both sides, to see what sort of case the House could present and the president's defense. And that makes sense. In every trial system, there is a mechanism for determining whether the parties have actually presented a triable issue, whether there is really some there that requires the further proceedings. And this body should take that common sense approach and hear what it is that the House managers have to say. Why are they afraid to present their case? They had weeks in a process that they controlled to compile their record, and they should be able to make that presentation now. And the one point that I will close on, we've heard Manager Schiff say several times that we have to have a fair process here, and I was struck by it that at one point he said if you allow only one side to present evidence, the outcome will be predetermined. The outcome will be predetermined. That's exactly what happened in the House. Let's recall that the process they had in the House was one-sided. They locked the president and his lawyers out. There was no due process for the president. They started with secret hearings in the basement. The president couldn't be present by his counsel. He couldn't present evidence. He couldn't cross-examine witnesses. And then there was a second round in public, where again they locked the president out. And we've heard, they just said that the president had an opportunity to participate. In the third round of hearings that they held before the Judiciary Committee, after one hearing on December 4th, Speaker Pelosi, on the morning of December 5th, went out and announced the conclusion of the Judiciary Committee proceedings. She announced that she was directing Chairman Nadler to draft articles of impeachment. That was before the day that they had set for the president even to tell them what rights he wanted to have and to exercise in their proceedings. It was all already predetermined. The outcome had been predetermined. The Judiciary Committee had already decided it was not going to have any fact hearings. There was no process for the president. He was never allowed to participate. So when Chairman Schiff says here that if you only allow one side to present evidence, that predetermines the outcome, that's what they did in the House, because they had a predetermined outcome there, because it was all one-sided. And for him to lecture this body now on what a fair process would be takes some gall. A fair process would be when you come to the day of trial, be ready to start the trial and present your case, not ask for more discovery. The president is ready to proceed, and the House manager should be ready to proceed, and this amendment should be rejected. Thank you.
Council, the House managers have 8 minutes remaining.
The House is certainly not asking the Senate to do the House's job. We're asking the Senate to do its job, to hold a trial. Have you ever heard of a trial that doesn't have evidence, that doesn't have witnesses? That's what this amendment is all about. Just a moment about the subpoenas. President Trump, refused to provide any information to the House, ordered all of his people to stonewall us. Now, it's been suggested that we should spend 2 or 3 years litigating that question. I was a young law student, actually, working on the Nixon impeachment many years ago. And I remember the day that the Supreme Court issued its unanimous decision that the president had to release the tapes. I think U.S. v. Nixon still governs the president. The House and the Senate should not be required to litigate U.S. v. Nixon back to the Supreme Court and down again for it to be good law. It is good law. The president has not complied with those requirements to the detriment of the truth. This isn't about helping the House. This isn't about helping the Senate. This is about getting to the truth and making sure that impartial justice is done and that the American people are satisfied that a fair trial has been held. I would yield now to my colleague, Mr. Schiff.
Mr. Philbin says that the House is not ready to present its case. Of course, that's not something you heard from any of the managers. We are ready. The House calls John Bolton. The House calls John Bolton. The House calls Mick Mulvaney. Let's get this trial started, shall we? We are ready to present our case. We are ready to call our witnesses. The question is, will you let us? That is the question before us. Now, Mr. Philbin says, well, if I showed up in court and said I wasn't ready, the judge would throw me out of the court. Of course, we're not saying we're not ready. But you know what happened if Mr. Philbin went into a court and the judge said, I've made a deal with the defendant. I'm not going to let the prosecutor call any witnesses. I'm not going to let the prosecutor present any documents. You know who'd get thrown out of the court? The judge. The judge would be taken out in handcuffs. So let's step out of this body for a moment and imagine what a real trial would look like. It would begin with the government receiving documents, being able to introduce documents, being able to call witnesses. This trial should be no different. Now, Mr. Philbin makes reference to the Cipollone letter on October 18th, which followed a Cipollone 8-page letter on October 8th saying, we're not going to do anything you ask. Part law, part diatribe, mostly diatribe. You should read it. It's a letter basically that says what the president said on that TV screen, which is, we're going to fight all subpoenas. The doctrine of absolute immunity that counsel refers to has, yes, it has been invoked or at least attempted by presidents of both parties and rejected uniformly by the courts, including in the most recent decision involving Don McGahn, the president's former White House counsel, where the court said that would make him a king. He's no king. And this trial has determined that he shall not become a king, accountable to no one, answerable to no one. And what's more, this idea of absolute immunity, this fever dream of presidents of both parties, it has no application to documents. Again, this amendment is on documents. There's no absolute immunity from providing documents. And as Representative Lofgren illustrated, when this case has gone to the Supreme Court, in the Nixon case, the court held that the interest in confidentiality in an impeachment proceeding must give way to the interests of the truth and the Senate and the American people. You cannot invoke privilege to protect wrongdoing. You cannot invoke privilege to protect evidence of a constitutional crime like we have here. And finally, with respect to those secret hearings that counsel keeps referring to, those secret depositions in the House were so secret that only 100 members of Congress were able to be there and participate. Only 100. That's how secret that chamber was. Imagine that in the grand jury proceedings in the Clinton investigation, or in the Jaworski, the Nixon investigation, imagine inviting 50 or 100 members of Congress to sit in on those. Imagine, as the president would like here, apparently the president insisting on having his lawyer in the grand jury because there was a case being investigated against him. Now, we had no grand jury here. Why is that? Why did we have no grand jury here? Why was there no special prosecutor here? Because the Justice Department said they're not going to look into this. Bill Barr's Justice Department said there's nothing to see here. If it were up to that Justice Department, you wouldn't know anything about this. That's why there was no grand jury. That's why we in the House had to do the investigative work ourselves. And yes, just like in the Nixon case, just like in the Clinton case, we used depositions. And you know what deposition rules we used? Those terribly unfair deposition rules we used? They were written by the Republicans. We used the same rules that the GOP House members used. That's how terribly unfair they were. My gosh, they used our rules. How dare they? How dare they? And now why did we do depositions? Because we didn't want one witness to hear what another witness was saying so they could either tailor their stories or know that they just had to admit so much and no more. It's how every credible investigation works. And this, the counsel can repeat all they like that the president didn't have a chance to participate, didn't have a chance to have counsel present in the Judiciary Committee or to offer evidence. They can say as much as they like. It doesn't make it any more true when they make the same false representation time and time again. It just makes it that much more deliberate and onerous. The president could have presented evidence in the Judiciary Committee. He chose not to. And there's a reason for that. There's a reason why the witnesses they've talked about aren't material witnesses. They don't go to the question of whether the president withheld the aid for this corrupt purpose. They don't go to any of that because they have no witnesses to absolve the president on the facts. You should want to see these documents. You should want to see them. You should want to know what these private emails and text messages have to say. If you're going to make a decision about the president's guilt or innocence, if you're going to make a decision about whether he should be removed from office, you should want to see what these documents say. Now, if you don't care, if you've made up your mind that he's the president of my party or for whatever reason, I'm not interested. And what's more, I don't really want the country to see this. Well, that's a wholly different matter. But that's not what your oath requires. It's not what your oath requires. The oath requires you to do impartial justice, which means to see the evidence. To see the evidence. That's all we're asking. Just don't blind yourself to the evidence. It's just, I yield back.
Thank you. The majority leader is recognized.
I send a motion to the desk to table the amendment and ask for the yeas and nays.
The question is on the motion to table. Is there sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
Are there any senators in the chamber wishing to vote or change his or her vote? If not, the yeas are 53, the nays are 47. The amendment is tabled. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena certain documents and records from the State Department, and I ask that it be read.
The clerk will read the amendment.
The senator from New York, Mr. Schumer, proposes an amendment, number 1285. At the appropriate place in the resolving clause, insert the following section. Notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedures and Practice in the Senate when sitting in impeachment trials, 1, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena to the Secretary of Senate commanding him to produce, for the time period from January 1, 2019 to the present, all documents, communications, and other records within the possession, custody, or control of the Department of State, referring or relating to A, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21 and July 25, 2019 telephone calls, as well as the President's September 25, 2019 meeting with the President of Ukraine in New York. B, the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, USAI, and foreign military financing, FMF, including but not limited to all communications with the White House, Department of Defense, and the Office of Management and Budget, as well as the Ukrainian government's knowledge prior to August 28, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance to Ukraine, including all meetings, calls, or other engagements with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. C, all documents, communications, notes, and other records created or received by Secretary Michael R. Pompeo, Counselor T. Ulrich Breckbull, former Special Representative for Ukraine Negotiations Ambassador Kurt Volker, Deputy Assistant Secretary George Kent, then United States Embassy in Ukraine Chargé d'Affaires William B. Taylor, and Ambassador to the European Union Gordon Sondland, and other State Department officials relating to efforts to 1, solicit, request, demand, induce, persuade, or coerce Ukraine to conduct or announce investigations, 2, schedule, cancel, or withhold a White House meeting for Ukraine's president, or 3, hold and then release military and other security assistance to Ukraine. D, any meetings or proposed meetings at or involving the White House that relate to Ukraine, including but not limited to 1, President Zelensky's inauguration on May 20, 2019 in Kiev, Ukraine, including but not limited to President Trump's decision not to attend, to ask Vice President Pence to lead the delegation, directing Vice President Pence not to attend, and the subsequent decision about the composition of the delegation of the United States. 2, a meeting at the White House on or around May 23, 2019, involving, among others, President Trump, then Special Representative for Ukraine Negotiations Ambassador Kurt Volker, then Energy Secretary Rick Perry, and United States Ambassador to the European Union Gordon Sondland, as well as any private meetings or conversations with those individuals before or after the larger meeting. 3, meetings at the White House on or about July 10, 2019, involving Ukrainian officials Andriy Yermak and Alexander Danieluk, and United States government officials, including but not limited to then National Security Advisor John Bolton, Secretary Perry, Ambassador Volker, and Ambassador Sondland, to include at least a meeting in Ambassador Bolton's office and a subsequent meeting in the wardroom. 4, a meeting at the White House on or around August 30, 2019, involving President Trump, Secretary of State Mike Pompeo, and Secretary of Defense Mark Esper. 5, a planned meeting, later canceled in Warsaw, Poland, on or around September 1, 2019, between President Trump and President Zelensky, and subsequently attended by Vice President Pence, and 6, a meeting at the White House on or around September 11, 2019, involving President Trump, Vice President Pence, and Mr. Mulvaney concerning the lifting of the hold on security assistance for Ukraine. E, all communications, including but not limited to WhatsApp or text messages on private devices between current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, and the following: President Zelensky, Andriy Yermak, or individuals or entities associated with or acting in any capacity as a representative, agent, or proxy for President Zelensky before and after his election. F, all records specifically identified by witnesses in the House of Representatives impeachment inquiry that memorialize key events or concerns, and any records reflecting an official response thereto, including but not limited to: 1, on August 29, 2019 cable sent by Ambassador Taylor to Secretary Pompeo; 2, an August 16, 2019 memorandum to file written by Deputy Assistant Secretary Kent; and 3, a September 15, 2019 memorandum to file written by Deputy Assistant Secretary Kent. G, all meetings or calls, including but not limited to all requests for or records of meetings or telephone calls, scheduling items, calendar entries, State Department visitor records, and email or text messages using personal or work-related devices between or among: 1, current or former State Department officials or employees, including but not limited to Secretary Michael R. Pompeo, Ambassador Volker, and Ambassador Sondland; and 2, Rudolph W. Giuliani, Victoria Tensing, or Joseph DeGeneva; and H, the curtailment or recall of former United States Ambassador to Ukraine, Marie Masha Yovanovitch, for the United States Embassy in Kiev, including credible threat reports against her and any protective security measures taken in response; and 2, the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice.
The Majority Leader is recognized.
I now ask for a brief 10-minute recess before the parties are recognized to debate the Schumer amendment. At the end of the debate time, I'll again move to table the amendment as the timing of these votes are specified in the underlying resolution. So I ask consent that the Senate stand in recess subject to the call of the chair.
Without objection, the Senate is in recess.